Hi guys, it's Kathy. I hope you're doing well. Yep, all we can talk about is Thanksgiving. It's gonna be that kind of stream. That's okay. Thanksgiving is great to talk about. Absolutely. I got everything I need. I got a 4 pack, no, yep, a 4 pack of Seagram's Jamaican Me Happy, a 4 pack of Seagram's some peach thing, and then 2 giant bottles of sparkling Moscato. Barefoot. Sparkling Moscato. I've never had sparkling Moscato before. It sounds delicious. Maybe too sweet, but it's fine. Oh my freaking lord, I miss you. Ugh, I don't have your. Well, I just looked at the next screen and I just realized we're not set up for court right now. I'm gonna fix it. Well, we look at the pretty It's Bill picture. Don't worry about what's happening behind the scenes right now. There it is. Alright. If you remember from yesterday, Hi Bill. Miss you. We started this trial in Judge McNally's courtroom, and Judge McNally was already irritated from the last case. You came for the Thanksgiving talk? Turkey. Turkey, turkey, turkey. Although something doesn't look quite right on my screen. Anyway, Judge McNally was in a mood. They wrote this contract. The contract made no sense whatsoever. Oh, what the hell? And then he had a judge badly for this woman. He felt really bad. And then he gets to this woman. Now, he has told her before, just in case you forgot. He does have a good look on his face. I should get a screenshot of that. He told her before that she is not an expert in what she's suing for. She's suing for attorney fees. She doesn't want to pay. That she needed an expert to get on the stand during trial. And she did not, in fact, get an expert like she was supposed to. So that's all we need to know about that. Let's press play.
And it's okay. Some people like to talk, and it fits his profession. The meeting was 3 hours and 40 minutes. And Mr. Schwab was talking about subjects absolutely not related to my divorce case. For example, his family, himself, his former attorneys, his former clients from Ukrainian or Russian demographics, about Trump administration, about immigration law, about stuff absolutely not related. So I was thinking he's trying to make a good impression on me, break the ice, stuff like this, okay? And then he started to explain me a divorce law. So it was another hour. And then finally, he started to talk about contract, his fees, and explain his fees. So Mr. Schwab, the reason why I decided to hire him at the end of this meeting, because I respected his experience and he assured me that he will get the best settlement for me. He said, Irina, I have tons of divorce cases. I know what to do. I know that guys like your husband. I know what they want. Just trust me. And I trusted him naturally. Because any woman or man who receives such bad news will be upset, and he looking for someone who will guide them through this process. So we signed the contract. At the end of the meeting, I paid a retainer fee for the future work to be done. And I was not aware about all these prior charges. Mr. Schwab said that he will send me monthly invoices. The first invoice was February 28th. That was the day when we had a conversation about our discovery going nowhere. I was upset and I had a thought to terminate him as my attorney.
On February 28th,
Yes.
okay?
So after this conversation, Mr. Schwab sent me an invoice within 2 hours. First invoice. I will be honest. I look at this. I just opened this. I look at the final page. I'm like, okay. I didn't even go through line by line because I was upset about, first of all, hostile conversation for almost 2 hours. I was upset that my divorce going nowhere. I felt like I'm losing my case. I felt like my attorney don't understand what we need to do because I was asking, let's subpoena the bank records, let's proceed with something. And he's like, no, let's do appraisals for premarital houses. Now we're going toward appraisals for premarital houses because Mr. Schwab covered this topic. It's another big chunk, 6,000 with something that he overcharged me for that. So Mr. Schwab told me, I offer you 2 appraisals for these houses. Okay. He explained me premarital properties and everything, but he's a licensed attorney. He should know better. I'm not an attorney. I'm a registered nurse. Why he told appraisals to do retro value 2014? We was boyfriend and girlfriend at that time, from 2014 to 2025. So it was 2 dates. That's why this data was not admitted on my mediation because mediator said 2014, was you married that year? No, what year it was married? 2020. He said it should be 2020 to 2025. Maybe you get something. So it was ineffective. And Mr. Schwab, as an experienced attorney, should know that. He still imposes appraisal service of his choice, Mr. Grab from Northville, Michigan, which I suggested I can hire my appraisal service. He said, no, I'm not responsible for whoever you will hire. I said, I can hire a licensed appraisal. He convinced me. Mr. Schwab is very good in convincing. He convinced me that this particular appraisal is very known to the court and judge. His data will be admitted without doubt, which was not. Also, I didn't know that Mr. Schwab will charge me for all the tones of conversation, emails, delivery of the checks, and everything in between me and mediator. I thought I will just pay for mediation service and that's it. So Mr. Schwab charged me $2,700 for his mediator work.
Well, you mean when you and your then estranged husband went to mediation, Mr. Schwab was there representing you, right?
No, it was, Mr. Schwab was terminated by that time. But I got appraisal results, reports. I got appraisal reports from appraisal service and I.
So what are you complaining about him charging you with respect to mediation? I'm not understanding that.
So my complaint is that Mr. Schwab sent me an email and said that whole appraisal service will cost you $1,000. Don't be cheap, just pay it,
Okay.
and maybe you get something.
Okay,
At the end, it was $6,700, not $1,000
for the for the appraisers?
for total appraisal service. $3,570 for appraisal service, and the rest it was his emails with appraisal, call with appraisal, 3 hours and 40 minutes staying in my house and going to these houses, which I don't understand how Mr. Schwab can justify, how you can charge legal fees for going to appraisal service. You know, these two people can operate independently. This is what they do for their living. He justifies this, oh, your husband could be hostile. If my husband would be hostile, these people will turn around and just leave. They will say, okay, we will just leave.
All right, so I want to get this straight. You're telling me that he told you it was gonna be $1,000 for the appraisal
I have
service?
email.
Okay, that's fine. And then you're telling me the appraisal service costs 3,500?
Yes, because how he explained, he said, I didn't know that, but appraisal service will cost you so much money because they will do retroactive value 2014
Right,
and then 2025.
right.
So 2014 was not useful at all.
But the appraisal service actually charged you $3,500
Yes,
to appraise the 6 properties and give you a value of the property as of that date, as well as beginning from the time that you started cohabitating with
Yes.
Mr. Rizal.
yes.
Okay, go ahead.
So instead of 1,000, it was 3,570. And then when I received my second invoice after 2 days after I terminated Mr. Schwab, I got all this billing for his work, which I highlighted in my counter complaint. Was the rest of the money, it was for his.
And how much was that?
It was, actually, I don't have my papers, but it was,
I don't want you to guess.
around 2,800 or
And
3,000.
was that billing that you're referring to, the 2,800, just for Mr. Schwab to go to the appraisals?
3 hours and 40 minutes just to go for appraisal service and 3 hours and 40 minutes for his coordinated work. So 6 hours and 80 minutes or whatever, how it adds up,
How much was he charging you again?
$375
Okay,
per hour.
okay.
So that was a surprise fee for me when I received my second invoice 2 days after I terminated Mr. Schwab. So after that, I look at the rest and I've seen that I start to calculate where this all came from. And I already paid $10,000 for kids that just started, had no custody, no children, no motion files, no depositions, no meeting with the judge, no mediation. How I already paid 10,000 and I own 16 more. That's what made me to file for counter complaint. For case that was just started and financial discovery was not even finished.
So let me just ask you, how much did you pay Mr. Schwab altogether?
10,000.
And that did not include the appraisal fees, or did it?
Appraisal fees was separate, plus appraisal fees, $3,750.
So you paid him, and he paid the appraisal company, right?
Yes. I paid him personally 10,000 and I paid him to pay appraisal service.
$3,750.
Yes,
And you're saying for him to attend the appraisals, how much, and to coordinate that, how much did he charge you for that?
so calculate 3 hour and 40 minutes plus 3 hour and 40 minutes and times 375.
Okay, so you're at about, okay. Somewhere in the neighborhood of about 2,800, because that's, okay, so that's 7 hours, 20 minutes at 375. Okay, what else would you like to tell me?
Mr. Schwab did numerous errors, as I said, with my filing my answer to complain. Then it was filed April 15 with the court. I went to the court. I went to the 3rd District Court in Detroit, and I talked to a supervisor and a manager, with everyone, and they personally checked for me. They said, we cannot.
Your Honor, I'll object 2 grounds. Any conversation, if she had any with somebody down at the court, is hearsay. Secondly, any testimony as to strategy, work, the file
Yeah,
that is lack of foundation. She has no
No,
choice.
they just confirmed that was no pleadings filed prior to April 15. That's only what they could tell me. They said,
Did you file, he filed the answer to complaint on April 15th though, right?
he's supposed to file this on January 10.
I know, you told me that, but he did file an answer to complaint at some point while he was still your lawyer. Right?
And how he found out about this?
No, I wanted you to
Yes,
answer that.
He did.
Okay, so he did file it, that is a pleading, an answer to complaint, just so you know, but
But it was overdue by 123 days.
I know, but sometimes lawyers do that. They agree, listen, we'll just get to these when we can get to these. They're busy people and he didn't harm your case by not filing that earlier because you never went into default.
But the opposing side could file a default judgment against.
I mean, I could get hit by a truck when I walk outside too. You know what I'm saying? Let's not talk about that.
Okay.
Okay, so what else do you want to tell me here?
So overcharging without my consent, appraisals, then discovery, my husband's financial statement, he never follow up, never forced opposing side to complete it properly. Interrogator is completely deficient. He charged me $2,400 for discovery, which led me to nowhere. So
When you say discovery, are you including the work on the appraisals or not?
I separate appraisals and discovery. Appraisals separate and
So
discovery.
when you refer to discovery, what are you talking about? His interrogatories to the other side?
In financial statement of my husband, that he didn't file any motion to compel them to file properly, the statement, and interrogatories, we never received interrogatories.
You never did.
While I had Mr. Schwab as my attorney, we never received the interrogatory.
From your husband's attorney.
Yes.
Correct. I got it.
I received them way after was my second attorney.
Right.
Follow up and, force them to do that. So lack of, like the Michigan court rule says, the attorney has to be diligent and jealously
You are a bright lady, you know that?
present.
You should maybe go to law school at some point, but sometimes we can read rules and not understand what's really going on in the practice. Do you understand what I'm saying? I mean, but I give you credit.
So I fired Mr. Schwab on April 14, 2025. The reason why I fired him, because we was arguing about interrogatories. I said, Mr. Schwab, file an amendment to interrogatories because they covering only houses. We need information from bank statements. He said, Irina, I will not do that because court will not allow me to do that. That's not true. So he didn't want to do that. He didn't want to look bad in front of the opposing side court or whatever. And I said,
You can only send 20 interrogatories.
Jealously, I like
I-
better.
That doesn't mean you have to. Go ahead.
so I wanted him to do an addendum, few questions about his personal bank statements, CD accounts, where the big money was. He failed to do that. And I said, you know what, Mr. Schwab, we will put our relationship on hold. I'm emotional right now. You emotional. We was emotional to each other. And I said, let's put our relationship on hold. Give me a couple days to think and I get back to you. He said, okay, I have a mail confirming that. 2 hours after that, he sent an email to opposing side about missing truck, something else, and charges me another $140. Okay, so that upset me, and I'm like, you know what? I'm done with that. And I sent him a letter that I'm terminating him. He ignored this letter completely. So next day, I was sending him another letter, and he responded finally on the second letter. And he finally stopped charging me because I couldn't tolerate any more charges.
Okay. I got it. Do you want to say anything else?
And the last thing that I want to say, that I felt obligated to file complain to Michigan Grievance Attorney Commission because I just felt like, you know, people who going through hard time like
They dismissed that, didn't they?
they didn't. No,
They didn't dismiss the committee?
no, they did not.
Your Honor,
I contacted the investigator, a senior, I have a letter from a senior representative of Michigan Grievance Attorney Commission, and I said, I have a trial on such and such day. Can I get some updates, maybe something? And he said, my investigation is still going due to complexity of the case and numbers of incidents.
Okay.
Your Honor, if this court believes it got a lot of paper, the attorney grievance has to have a foot. Again, they have done nothing, zero. Because as, you know, that's probably true. I mean, what she has filed is beyond comprehension. But that is going nowhere because a grievance, as you know, this is a dispute over fees. It's not sex. It is not the other thing, stealing property. It's-
I understand. Okay. I get it. What else do you want to tell me?
Well, talking about sex, Mr. Schwab, on his first meeting, when we were signing the contract, made a remark, and I included this in counter complaint too, salacious comment. He told me that I know men as like your husband, and he will accuse you to having sex with me, which I looked at Mr. Schwab, and I don't want to say nothing about anything, but I said, I don't think so. This is what I told him, and he said, oh, you want to tell me that I'm too old for you? He repeated this comment a few times during our 3 other meetings.
Okay.
That's it, Your Honor.
All right. Why don't you have a seat?
Your Honor, I would like to recross 3 questions.
Okay, go ahead.
Miss St. John, who was the woman sitting out at the reception desk when you were there on that first meeting?
On December 13, 2024,
No, the first.
was
meeting.
no woman sitting
Why
at the desk.
Sitting there?
No one was sitting there, Mr. Schwab.
Uh,
Good try.
Now, when you're complaining about the fee that the appraiser charged you, you paid that, didn't you?
My appraiser, it's your appraiser
No.
charged me, your reference
The
appraiser.
appraiser that we used, you paid it, didn't you?
I paid
You didn't
$3,570.
object, Didn't you?
I did objected this with you.
But you,
I objected this with you and you convinced me.
there were 7.
It will be in my cross-examination.
Miss St. John, there were 7 homes appraised for appreciation purposes. That's less than $500 a house.
Was 5 houses.
Well, you own 6 plus your marital property, right?
4 premarital houses that my husband owns and a marital house, which I said, I don't want to appraise. I have emailed.
Can I ask you a question? Do you know what the combined total of the appraisal amounts was for all those houses? Do you have any idea?
I'll tell you, for premarital rentals was, I would say, 600.
Are you saying, I'm asking you, just what is the combined value of those appraised homes? Exclude the marital home?
600. Each would say in average 150.
Okay, good enough. Okay.
Plus,
So there was some money involved. You have to acknowledge that. I mean, he was trying to get you appraised. He was trying to get you 50% of the value between the time you started cohabitating with Mr. Rizal in 14 and up through the time that he was representing you. So there had to be some kind of money involved is the point.
But Your Honor, I'm not objecting this money that I paid to appraisal service. I'm objecting all the rest of the money that Mr. Schwab charged to enrich himself. I never claimed that I want back $3,570 for appraisal service I paid. I never claimed this.
Okay.
Miss St. John, I think you testified that you were surprised that I charged you for telephone calls.
Your Honor, I thought we will exchange now, and I see that it's just Mr. Schwab talking as always. I would like to object to that.
Okay. Well,
He had his time to ask me. Now
So wait a second, wait. Let me tell you how we'll work it now. He gets to ask within the scope of your testimony. And then you can sit down, then he's going to call himself. And then you're going to have the opportunity to cross-examine him. And then he can, so to speak, redirect himself. Okay? Go ahead.
It testified that she was surprised. You didn't know you'd be charged for telephone calls. You wouldn't be charged for emails. You
Yes,
wouldn't be charged for,
not excessive emails and phone calls.
okay, are you testifying that every time I did a piece of work, I had to get your permission to do it?
You don't have to have my permission, but your charges has to be reasonable, and they was unreasonable. The amount of work that you did and money I paid, unreasonable.
And you got the billing on February the 26th. Did you say this is unreasonable?
I did not object to this, but I am objecting your second invoice in addition with the first one.
Finally. The appraisal, in addition to trying to get you 50% of the appreciation during 14 through 25, we were also trying to get you 50% of the rental that he made, correct? Because you were gonna testify that I went over there and cleaned up the houses, I schmoozed or I interacted with the tenants. I was his partner, correct?
There is all type of appreciation
Pardon?
from the marital time to now and cohabitating.
And we're gonna get all of it.
Did you get all of it?
I wasn't your attorney. You fired me. I have no further questions.
Okay, you can step down now, and you're going to testify, counsel?
Robert, you
All right, you can clap here.
know.
And you told me this is going to take 10 minutes, your testimony? All right.
At least that's what I'm gonna testify to.
Raise your, raise your right hand. Solemnly swear affirmative penalties of perjury, the testimony you'll give in these proceedings be the whole true self you got.
Thank you, Your Honor.
Okay, have a seat.
My name is Paul Schwab. I'm a licensed attorney. I work by choice.
Is that 100% of your practice, pretty much?
Pardon?
Is that, what percentage of your practice is divorce?
At the time I was representing Miss St. John, probably 20-30% of my
Okay.
practice. Prior to that, more, but again, divorce work's a young man's work, and I'm not a young man. So I really stopped doing it. An unusual case, Miss St. John had really, a difficult life, immigrated from Ukraine. Her first husband, I believe, was tragically killed. They had a young child, and Mike Azell was, I believe, her husband's friend, and they married, or they lived together. Mike Azell, helped her. They then got married, and it's
I
very
was thinking
tense.
that too,
Miss,
Kelly.
St. John is a very strong woman and self-sufficient. She had problems with her daughter. Her daughter's a teenager going through a lot more than most teenagers are going through. I believe that Miss St. John was able to bring her family to this country on a legitimate immigration visa. I know that Miss St. John one afternoon appeared to my office and introduced me to her mother, introduced me to her brother. That's when I learned that they're living in an apartment building over on 12 Mile in Lasser. I know a Russian immigrant who lives there, Olga. And again, I even asked her parents or her mother, and there was some acknowledgement that, yeah, there's somebody there. So anyway, Miss St. John, we work together. I have, an extensive divorce file. I would take her telephone calls. She would question, she would send me 4 or 5 pages of emails. I want you to do this, I want you to do that, I want you to do that. File more interrogatories, do this, do that. And again, we're dealing with the Wayne County Family Court. And we got a 60-day deadline, and that judge is gonna set this for a mediation hearing. And I better be ready because we've got to have some theory. In addition, this theory of appreciation is really not that well codified in case law. But again, our strategy was we are going to go to mediation, and this is going to be a negotiated settlement. I had a lot of information on appreciation. He bought these homes as really a slum land. They were run down. One of them, I think, $60,000 to buy. Now they're worth $750,000. There's a lot of appreciation. And Michael Lizelle, a nice guy, but he's a smart businessman. He's not going to give away his money easily. He had his first attorney. Again, I know why. He told his attorney, I'm not giving him that information. Well, he fired that attorney, got the second attorney. Then I filed the interrogatories, and again, I listened to the earlier case when it's 20 questions, no subsections. Well, mine had 13 questions, but there were a lot of subsections, but the other attorney didn't object. And then I got this email, stop work. Well, when a client says stop work, I'm not going back there and saying, oh, please give me another chance. I respectfully said, thank you. We had a nice friendship, a nice relationship. I've stopped work. I covered my backside. I wasn't going to have her say, oh, why'd you stop work? Because you told me to. And again, I had attached it to some of the myriad pleading. And again, I had email after email after email and talking to her. And again, yes, this first meeting when you are representing a young woman whose whole world is collapsing, they're looking for comfort, they're looking for strength, they're looking for support. And that's what I tried to give her. And I tried to prepare her. Her husband already lied to her about filing the complaint, just to stick it to her and twist the knife. And that upset her to no end. Then we got a copy of the complaint, and as soon as I gave it to Miss St. John, I emailed it to her immediately. She was served. So again, husband's playing games with her. Husband was playing games with her throughout this entire thing, even playing the daughter tragically. The daughter, really almost treated him like, a father figure. Again, nothing untoward, but very, very strong emotional attachment. I felt badly for this young daughter, 13, 14, also questioning, her sexuality, her sexual identity, depression. It's just a very, very dangerous. And I tried to comfort Irina on that. Tried to support her, but again, I wanted to prepare her that look, your husband isn't done attacking. And one of these husbands always accuse you of having sex with your attorney. I said, look at me. This is on her side. And I told her, my wife works here. I don't disclose to clients my wife is sitting up there at the desk if I have some material motive. And again, giving her records and the phone records, I don't know, but I try to keep her informed. Again, a narrative building, when you look at it, I didn't make this up 2 days ago. We keep contemporaneous records. I was trained as an insurance defense attorney. I used to keep insurance companies happy. And I keep copious records. No objections, no nothing, until I decide, you owe me money, I'm gonna file a lawsuit. And then she files these complaints. And again,
I'm sorry, how much do you think she owes you right now again?
$1,512, I believe.
So there's a bit of a disparity. Yeah, 1627.70. But she told me, right? I think she told me that she paid you.
She paid me $10,000. She gave me two retainers. When the first billing was sent to her,
So actually, your total bill for her case was 11,627.70. Am I reading you right?
that's correct. Because the first billing was $6,176. I applied her $5,000 retainer, that left an unpaid balance. I carried that forward. After the February 26th, 2025 billing, she gave me another $5,000 retainer. She was happy with my work. She wanted me as her attorney. So she gave me that money and I applied it, as I am required to do, to the final billing. And when I applied it, I listed, if you look at the final billing, it says so much for attorney fees. Previous balance, I want to say $176. I apply the $5,000 unearned second retainer, and that left the balance. Every penny is accounted for. Every,
Let me ask you this. What did you think his net worth was? His? Had you gotten that far?
Counting the Grosjean house, the Grosjean house is probably worth $600,000-$700,000. They're not on a canal, but it's a nice house. It was probably built, I would say, in the mid-60s, but it's nice. And he restored it because I was there one day to see the house. I wanted to see what we were dealing with as marital, because she's gonna get half of that house.
Right.
They bought it together, and I think she even put most of the money down. So she was gonna get it. Well, I wanted to be able to tell the other attorney I was there. And it would be a house that, quite honestly, my wife and I would buy. It's on Grosjean, and that property is worth a lot. So I would say that house is probably worth $600,000, $700,000, and he's got all of this rental property.
Plus, what else did he have? Do you have any idea?
As I believe,
No, but I mean, did you get far enough to determine whether or not he had money in
he's got some money in
stock markets or
I
retirement funds?
because under divorce law, they are supposed to, under the new thing, there's I'll call it a FIFA form, financial information disclosure form. And you're supposed to list everything. Well, the attorney gave it to him, he just wrote it out in handwriting and sent it back. And I objected to that. I told this Mark Gilbert, I said, Mark, there's a lot of deficiencies and correct this, correct that, correct that. Because also, the judges in the Wayne County Family Court expect two intelligent attorneys to be able to work out discovery questions. And I did, and I said, Mark, give us this information, give us that information. She says, subpoena. A layperson doesn't understand. You send a subpoena to Comerica, it's 3 or 4 months, and they charge you $1 a page. Whereas I can get the same information from the attorney. So the attorney and I were working. Also, the reason the answer wasn't filed that far, because the attorney said, Paul, lie low, let's talk, let's see if we can.
Right, I figured.
Yeah.
All right.
Yeah, so that is it. And like I say, again, I still respect Irina. She tragically does not understand what went on in a legal point of view. She expects us to be like too late, it doesn't work that way in divorce law.
Do you have questions?
I do have a few questions.
Okay,
First question, Your Honor, you asked Mr. Schwab, how do you think the marital house in Brazil cost? And he says, I think it's $700. There is no $1,000. There is nothing to think. Appraisal was done. I paid for the appraisal, and it stated it's worth $430,000. It's not on a quarter, and I didn't want to do appraisal for the marital house, and I insisted with Mr. Schwab in my email that I don't want to do appraisal on a marital house because I will get 50% anyway. It's a marital property. We put money together, 50-50. We pay mortgage together.
okay,
So.
okay,
it
but
was-
this is the time to ask them questions.
Yeah, so Mr. Schwab, did the appraisal service appraised my marital house in $430,000?
Yes, can I ask you, you wanted that house and you were willing to waive all of your interest in the rental properties, correct? You wanted to continue living in Grosse, correct?
I wanted two options, or stay in a house with my daughter or sell it and split it 50-50. That's why I said appraisal not necessary, because if it will be sold, it will be split by law 50-50.
And what were you
My
gonna
next
split? What
my
were you
next
gonna split?
question-
What value were you gonna split if you didn't have a licensed appraiser?
The mediator used Zillow appraisal value, opposing side used Zillow appraisal value as
Okay, why don't we do this? Why don't you stick to the questions and you're gonna just give the answers? Go ahead.
My next question is, did you just stated that you've been in my house before?
Yes,
Can you please tell me when you've been in my house before? State the date, please.
there was no snow on the ground, so I would have to say, you hired me in December. I recall being there probably end of January.
What you was doing in my house?
I was with you. Your husband wasn't there, and you walked me around, you showed me the lower level. Yes,
Your Honor, I have no recollection of this event happening. Mr. Schwab first time entered in my house at the day of the appraisal.
Okay, so you gotta tell me
Oh.
that on your other,
Miss St.
I don't
John,
know how to address that. It's,
well, you dispute that.
Miss St. John, I wasn't in your house on the day of the appraisal. I stood on the driveway. Your husband, maybe the appraiser and the appraiser's assistant, your husband, but they were already out of the house when I arrived, because I got lost.
I object in this, Your Honor, because that's absolutely not true. Mr. Schwab first time came in my house on a day of the appraisal service. He been physically inside
Okay,
my
you're
house.
gonna have to tell me that when you're testifying. Right now, you're just asking questions, though.
Okay,
Does it really matter whether he was in there before the appraisal, after the
it
appraisal?
doesn't matter, but when somebody says something that never happened, I have to
Okay,
object
okay, fair
to
enough,
something.
fair enough.
So, also, my next question is that, so it was appraisal of the marital house. The premarital for rental properties, that did you told appraisal service to appraise premarital for rental houses, on retro value 2014?
Yes,
And did you know that at that time legally was not married?
yes,
And did you know or anticipated that this value probably will be not accepted by court or mediator?
there's no way to predict that. This was negotiation.
Okay, did you order appraisal value at the marital year of 2020?
I believe that's incorporated in the appraisal report, but you have to understand that you are not entitled to appreciation from 2014 to the day of the marriage, because that was your husband's separate property. We were
But
going
you
under.
still order.
Just let him finish.
We were going under, and I explained this to you, a business theory that while you and your husband were living together, you were business partners. You were working together to enhance and make a profit on that. And we were really settling or putting a claim in that you were gonna get 50% of the appreciation as your husband's business partner. That is the theory. It's a unique theory, but it was for the purposes of mediation only. I didn't know what the judge in the family court was gonna do.
My next question is, as a licensed attorney with extended experience, do you think it would be more appropriate to order appraisal date of 2020, year of the marriage?
No, because you have no claim to that property. That is your husband's separate property. That those rental homes are non-marital. Unless your name were on those rental homes, you cannot get any money for them, even though you're married.
Mr. Schwab, my next question is, did you receive a request for production from me, but through the Michigan filing?
In this case,
Yes.
yes,
Did I ask you to provide any document, note, letter, email, report, anything that proves my authorization for any search-related work or legal representation prior to December 13, 2024?
I don't remember, but I know that the requests for production were rambling, non-specific. Couldn't even understand, and I objected to those requests, and you never asked the court to rule on whether or not my objections were valid. And
You
so I
responded.
answered those.
Response to request one is not possible. My next question is, if after our conversation on a phone prior to December 13, if I never show up in your office on December 13 to sign that contract, how would you claim all the charges? How would you present them to the court? How would you sue me for that?
First of all, you have to understand, to have a contract, you don't need a piece of paper. You can have a request, or you request, Mr. Schwab, I want you to do something, or I offer to do something.
Can you present this
Wait,
request?
let me finish.
Okay, you call me and I offer to go down to the court to look at it. And you accept that offer. That is a contract. Then I can assure you that with that type of an issue, I would have said, I'm gonna have to charge you for that.
Did you disclose your attorney fee prior to December 13?
More than
Did
likely,
you explain them to me?
more than likely in the first telephone call, I would have said,
Wait a minute, ma'am. Wait, no. You got one?
I'm talking about the practice of law. You called me, Mr. Schwab, I want you to represent me, I'm looking for a divorce attorney. The first thing is, can you afford me? And I would have said, I would like to represent you, but my hourly rate is $75 an hour. I charge, it's computerized, I charge by tenths of an hour. You have to pay me for this, this, and this. Sometimes there are no charges. Then we go forward. But it's not fair to a client to have them come in, waste their time, and then break the news to them. It's $375 an hour. I might as well say it's 3.7 million. There are some people who cannot. Now, you said, I'm an oncology nurse. I work for Carmanos. I could handle it. Then, of course, we discussed fees.
I will object this. We did not discuss fees on a first conversation.
So you're gonna have to come back up and tell me that when you testify again, okay?
My next question is, you produced two orders, status quo and stipulated mutual restraining order when you filed the answer to complaint.
Yes.
Did you file them?
No, I did not.
But did you charge them? Did you charge me for them for production of this
I
orders?
probably did. I did the work.
Okay,
But the reason they weren't filed was because I talked to your husband's attorney, and we had an agreement. There was not gonna be any destruction of assets. That's why you get the injunction. And secondly, you were living together, you were sharing your bills, you were sharing utilities. You weren't gonna be out on the street. So to save you money, I didn't file either one of those. Plus, once the attorney's involved, we have to have a court hearing, and that's gonna charge you another $1,000. It wasn't necessary, and you were not damaged by it.
so according to your answer, you didn't file answer for my answer to complaint. These two stipulated order, you charged me for them, but didn't file them to save me money.
Yes, I did the work, but I didn't file them.
Why did you do the work if you and the other lawyer had an agreement?
Because at the time, I didn't know if the husband actually filed the complaint. Because I went down there and there's no record of it, nothing. Miss St. John was very.
For those of you just stumbling in drunk, they're both suing each other. He is suing her first for attorney fees. She fired him. She paid him $10,000, and I think she paid him $3,700 for an appraiser. And then she is countersuing for something. I don't know if it's $1,200 or something silly. He's saying she owes him like $1,300. It's all silly. The judge is done.
Very, very anxious. So I did and then the second time, once I got the complaint, the other attorney had no injunction, which is not at all unusual. So I prepared the property injunction. You cannot let, insurance policies lapse. You can't sell property, you can't conceal property, you can't damage property. That's property. The status quo says, Mr. Odell, you have to contribute keeping the utilities on. You have to contribute to the house. Those are the two. Those are standard. That would be malpractice not to, unless you have the other attorney say, we're not going to have that problem. And we never did. They continued to live together. So yes, I was prepared.
Okay.
Yeah.
Mr. Schwab, did I provided you with a copy of, did I provide you with original of complaint and summons on December 13, 2024 when I came to your office? Because with certified mail, did I provide you with original?
I believe you did, but by that time I had a copy also. But I believe you came to the office and said, I was served, yes. Again, I think they served you by mail, but I'm not sure. But yes, you came with the complaint and the summons, but I had that already from, my meeting at the Wayne County.
I was served at the same day. I was served at the same day when I came to you gradually.
Yes, you were. I didn't serve you.
Mr. Schwab, after you received the financial statement from my husband and you seen that it was grossly deficient, a lot of information was missing, what was your follow-up on that?
I sent his attorney, well, first of all, you and I spent considerable amount of time. And I believe I'm paging through my divorce file. I believe you gave me some notes as to what was deficient. Then I have an email here to the attorney that said, Mark.
I hate to do this,
Yeah.
but it's 1:15.
Yeah.
I'm gonna go have some lunch. And you guys can have lunch. Can we all be back here at 2:00?
Okay.
Okay?
Yeah.
See everybody back here then. Thank you.
Yeah, I thought this was the end. It's not. Let's find the end. So this was 7 days ago. And this was 4 hours and 36 minutes long. Thank you so much, McNally, for not taking down your Zoom. It should be this one right here.
Tell you what the charge is. You're charged with possession.
Eesh. Hold on.
Five M 618-4948. Attorney, have you?
No, Caitlin has.
Am I just an old man that you just don't, he doesn't understand?
No,
And
you're making sense. I just feel like,
what does that mean? That's it. Right?
I don't see the end. I don't see the end of this. He didn't put it up on his live streams. Son of a gun. I could tell you what happened. She lost. And he won like $1,600 more. Because he told her before they even went to trial, she had to bring a lawyer in to as an expert witness to explain how lawyers' fees work and why his is not right. And she refused to bring an expert lawyer in. So this lawyer just presented everything he did, and she lost. Oh man, I bet she was big mad. Big mad. We should all just, Kelly, we should all just start taking pictures of prices and flooding Discord. Look at this. Look at gas. $3.39? What? Thought it was going down. Oh, Mel, I'm going to move right beside you. Yeah, an expert witness would have charged her, abso-freaking-lutely. This lawyer only charged $3.75 an hour. That's really not bad. And it was a complicated divorce. So 10 hours is not, like, she got charged $10,000. That's really not a lot of money for a complicated divorce. You know what I mean? I should put something on. I should put something else on. I got Judge Caulfield. We can end the stream with Judge Caulfield. So they started playing Christmas music at my job like in October. And even though I haven't worked in 2 days because we're off this week, I cannot get the Christmas songs out of my head. Actually, yeah, let's not go to Judge Caulfield. I don't know how long this is. I didn't watch it. But this is what we're going to do instead. We haven't seen this guy in a while. In a hot minute. Oops, that's not right. Stansberry. I don't know if it's good, bad, or I don't even know how long it is. But we only need like 30 some minutes more. So let's go to Ohio, to Licking County, Ohio.
Logistical standpoint, they handle the cases together.
The only thing in pre-trial, we had discussed running my case consecutive to Mr. Mead's. Thinking maybe we just reverse it because he's gonna ask for a report date. And that might give us time to get Mr. Mead's.
And this is a second and 10.
Well, it gets a little complicated there. In the Mead case, which is 1794, they withdrew their suppression. I had agreed to dismiss the A2. Don't know that I've done that yet. And he would plead to the A1A, which would constitute his second with intent. I also cut the deal with Mr. Mead that I would not charge his client with an A2 in Mr. Brigden's case, which was never charged, and that they would be, and plus he has the ALS in Mr. Brigden's, and that the 10 and 10 would be run consecutive. Unless the defendant would like to get it over with and waive counsel, we could proceed on both. Other than that, I think we need Mr. Mead.
I tend to agree. Mr. Brigden, do you want to take a minute? I can handle these other cases. You can go into the jury room with your client and the interpreter to discuss. I think to make sure that we're all on the same page, Mr. King's proposition is that A, we either need to continue Mr. Mead's case.
Wait.
B, if the defendant wishes to waive.
What do you mean it's not the season? What do you mean it's not the season? There's no season for barbecue. That's an any day, any time type of food. You can eat that right. That's like saying pizza's not the season. Barbecue's delicious.
Waive his right to counsel on that case, and then you can certainly assist him as standby, and we can resolve both of them together. Or we just resolve yours and then get in touch with Mr. Mead. So why don't you discuss with Mr. Kodka how he wants to proceed? If he wants to waive his right to counsel on the 1740 or 1794 case, that's fine. We'll execute that on the record and we'll resolve everything. But Mr. King's recitation of what was discussed as far as disposition is accurate. Okay. Okay. So we'll set this aside here. Okay, next up is going to be Donnie Dowdy. Oh, that's Brigden's as well.
Yeah.
So it's not going to be Donnie Dowdy. It's actually going to be Bernard Sangrola. This is case number 25 TRC 06677. State v. Byned Sangrola. That's you, correct, sir? He's here in the courtroom with his counsel, Mr. Wright. We have Mr. Savage here on behalf of the state of Ohio. This matter comes on for further hearing, having been scheduled for a change of plea. The defendant's charged with OVI impaired, OVI per se, a seatbelt violation, and a left of center charge. My understanding, Mr. Wright, is your client's going to be changing his pleas from not guilty to guilty?
Correct.
Is that true, sir?
Yes.
And are you aware that you don't have to do that? Meaning nobody can force you to plead guilty. Do you realize that?
Yes.
And do you understand? Yeah, try to speak up as much as you can because we are recording our proceedings. You're presumed to be not guilty here, which means I have to assume and believe that you're not guilty of these offenses. until and unless the state of Ohio meets its burden beyond a reasonable doubt. Do you understand? And that's proof beyond a reasonable doubt, I should say. Are you aware that you have a right to have a trial with a judge or a jury where the state would attempt to meet that burden? Meaning they would call witnesses that they believed had evidence sufficient to sustain a conviction against you. You would have the right to question those witnesses after they'd finished testifying on behalf of the prosecution. You would have the right at that trial to issue court orders known as subpoenas, which would require your own witnesses to attend. And then finally, if you didn't want to testify at your trial, you wouldn't have had to. Nobody could have made you. And the decision not to take the witness stand couldn't even be held against you in any way. Do you realize that?
Yes.
Okay. Now, by pleading guilty, you admit to committing these offenses, which means the state no longer has to prove anything in order for me to find you guilty. Furthermore, you're going to give up your presumption of innocence, and you will be waiving those rights we've discussed, including your right to a trial. Do you understand that?
Yes.
And if I accept your plea and enter convictions today, then I am going to impose sentence upon you. I believe this is a true first-time offense, correct?
Yes.
Okay. So you're looking at up to 180 days in the county jail, up to a 3-year license suspension, and a maximum fine not to exceed $1,075. Do you have any questions about that? That's the maximums, okay? There are mandatory minimums, meaning at the very least, I have to fine you $565, I have to suspend your license for at least 1 year, and I have to sentence you to serve 3 days in jail. But instead of the jail, I can't order that you do a 3-day driver intervention program. Do you understand? The seatbelt violation carries a maximum penalty of a $30 fine, and the left of center is up to $150. Do you have any questions about any of that? All right, very well. Has anybody threatened you in any way or promised you anything to get you to do this?
No.
Are you under the influence of anything right now? Are you satisfied with Mr. Wright's advice and representation?
Yes.
And are you a citizen of the United States of America?
Yes.
Then I find that your pleas and your waivers have been knowingly, intelligently, and voluntarily made. Court will accept the same and enter convictions upon the record. Mr. Wright, would you care to make a statement in mitigation on behalf of your client?
Yes, Your Honor. First of all, this is the first OVI offense. The court, we did have a suppression hearing, if the court recalls. The defendant was very polite, cooperative, understands English generally well. With maybe a little bit of misunderstanding of some specific terms. He understands the error of his ways. He has attended and completed a 3-day intervention program, which I have a certificate here to present to the court. We are asking for the minimums. He is employed. He works, I believe, night shift over at Victoria's Secrets or Kohl's warehouse in Reynoldsburg. I do have a question. So his license has now expired. I believe he has to go to the BMV to get his license renewed and then immediately resuspended. But he does need occupational limited driving.
Soft pretzels is one of my favorite foods ever.
Yeah, and as far as
I love
renewing
it.
his license, I sign off on an entry at least once a week that grants defendants leave to go to the Bureau, orders the Bureau to allow them to renew or retest if necessary, and then confiscate the license immediately.
Okay. Is that an entry I prepared, or is that a standard entry? Or?
So, basically, he would need to submit a request in writing to the probation department saying, hey, my license is about to expire, I need to renew it, and it's just got suspended because of this conviction. They'll generate the entry themselves, send it up to me. As far as the privileges are concerned, we prefer to have you fill out the court's form entry.
Okay.
And the bailiff can make that available to you.
Okay.
Anything further, Mr. Wright? Mr. Sangrala, you have a right to make a statement before I decide what to do here, but you don't have to. Is there anything you want to say? No? Okay. And Mr. King, did the state, or Mr. Savage, I'm sorry, did the state have any further position on sentencing beyond the pretrial discussions on the day of this?
No, Your Honor, we'd proceed on the per se, no reason to deviate from the mandatory minimums and the fines associated with the minor misdemeanors.
Okay, thank you. So his 90-day ALS is expired. Has he renewed? All right, very well. It's going to be the sense of the court as follows. On the OVI charge, I'm going to sentence the defendant to serve 30 days in jail. I'm going to suspend 27 of those days, meaning you don't have to serve those days as long as you follow the rules of probation. I'll put you on probation for 1 year. One of the terms and conditions is that you successfully complete a 3-day driver intervention program. It's not necessary for me to see the documentation regarding the already completed, but it'll just need to be shown to probation. That gets credited towards the 3 days that I didn't suspend, so as long as you follow the rules of probation, you don't have to worry about serving any more jail time as a result of this conviction, okay? If you don't do what you're supposed to do, then you and I are going to meet again in the courtroom, and it's not going to be nearly as fun, okay? Additional conditions are, if there were any recommendations made coming out of the DIP for any additional counseling, you'll be required to do that until released in writing. If they didn't make any recommendations, then you won't. You're not to consume alcohol to excess. You're not to use any illegal drugs or abuse any prescription medication. You need to maintain suitable employment and follow any other rules the probation department sets for you. Now, the fine's going to be $565. That's the minimum. I'll order that you pay court costs, and I'll suspend your license for 1 year. I'm going to make that effective as of today, but with the notation that he's to receive credit for the 90 days that he's already served, and he's eligible. He can submit a renewed application for limited privileges. As a first-time offender, it's very customary for the court to require interlock on a pre-conviction basis, but once the defendant's under the court's supervision, the court more often than not removes that interlock requirement. On the remaining charges for the seatbelt violation, it's a $30 fine. On the left of center charge, it's a $25 fine. We will give you time to pay if you need it. One thing that I would point out, however, is if you put in a new request for limited driving privileges and it's granted, you need to be 100% sure you're allowed to go where you're going, because if you're outside of those limits and you get pulled over, you're going to get charged with driving under the OVI suspension. That charge also carries a mandatory minimum 3 days jail term.
Where were you?
But unlike the OVI, there's
Where
no
were
alternative.
you?
It's 3 actual days in jail. So if
I
you're a
wanna
little bit
know.
unsure about whether you're allowed to go to a
Where
certain
were
place,
you, Michael?
wait until you get in touch with the probation department and get a definitive answer. All right? Okay. Now, do you have any questions, sir?
Josh won't tell me.
Retroactive back to the day of violation for the driver's license.
Well, because if I do that, then he's going to end up getting credit from October the 19th until today, and he's not entitled to credit from October. It's just the way that I reflected. They're going to show that his license was suspended from, it should come out on his BMV as being suspended from,
July 19.
no, it'll come out as being suspended, I think, from the 25th of November, but it'll reflect that it's only
have an
going
idea.
to be 90 or,
Please, tell me. Please, I need to know. Did that work? Did yours
270
work?
days instead of 365. All I can tell you is that this is the way I've been doing it for more than a decade, and the BMV gets it right. He doesn't get extra time.
Okay,
Okay?
so he'd be eligible next July, 1 year from day of,
Yes. Yeah. It should terminate on July the 19th of next year.
okay,
Okay?
all right.
Well, no, actually, that's not right. So he would have the 90 days up until October the 19th or thereabouts, and then there's no more credit until today. So he's going to have 270 days from today's date before it expires. Because if you make it effective from the date of the citation, then what ends up happening is the Bureau would say, okay, fine, it starts on July 19th this year, ends on July 19th of next year, but he would not have actually been under a suspension from October until today.
Never.
And so he would be getting credit for days that he actually wasn't under the ALS.
I'm not sure I followed that, but I'll take your word for it.
Okay.
I mean, I've always had judges retroactive back to the day, and, for that reason, I didn't have him renew.
Well, it usually comes up in situations in which it's been a positive test and a 90-day ALS, because sometimes, the cases don't get resolved until after it's done. And so the court needs to reflect that they're going to receive credit for the ALS, but it still has to impose the 1 year. And again,
Does anybody know what that is on his wrist? Anybody? I'm always where I should not be. Constantly. I mean, I don't have Apple products. I have my Google phone. But it looks like an AirTag. Is that Is that one of those Apple AirTags? Or is that something way different? I can't think of anywhere you're not supposed to be, though. There's nowhere off limits.
And it's inaccurate to say he's been under suspension completely and continuously since July the 19th, when the ALS itself terminated in October. So that's why I've reflected the way that I am. They always ask us for suggestions on presentations at judicial conferences. My next one will be for a presentation from the BMV to make heads and tails of some of the stuff that they do.
He used to have this ball that hung down, and now he
Mr.
has
Savage,
this
anything
disc.
further?
No, Your Honor.
All right, very well. You may go with the bailiff. Okay, Mr. Brigden, why don't you come on back up? We're back on the record in the Kodka cases.
Oh, Chris, take this up. I don't think I've done it yet.
You can put anything you want in Discord.
Yes, on that one.
Go for it. Well, don't get political. Other than that, never bash another channel, ever.
You don't
Other than that, you can put anything you want
So
in
again,
Discord.
this is 25
We love
TRC
it.
1794,
Love it.
25 TRC 6415. Mr. Kodka is present with counsel. The court during this hearing, before our recess, has previously sworn in Mr. Adhikari to serve as an Nepali interpreter. And Mr. King remains on behalf of the state of Ohio. Now, the court should point out that Mr. Brigden has been appointed to represent the defendant solely in the 6415 case. In the 1794 case, attorney of record is Darren Mead.
Where is Darren Mead?
Mr. Brigden, we're scheduled for a change of plea here. So the easier case to talk about is the one that you're appointed on.
I didn't say that.
That's pretty straightforward. You're on it, we're here, we can do that. For the 1794 case, with a different attorney being attorney of record, the court would not be able to go forward unless it was the defendant's intention to waive his right to counsel in that case. And with the understanding that the court would certainly allow you to speak on his behalf. How did he wish to proceed?
Your Honor, he would waive counsel in the 1794 case.
So, Mr. Kodka, your attorneys explained that you wish to waive your right to counsel on the case where you had Mr. Mead as your attorney. Is that accurate, sir?
Yes.
I'm going to read you the following language because in a moment I'm going to be giving you a form that's titled Attorney Waiver. And you don't have to waive your right to a lawyer, but if you do, it's required to be done in writing. Understand? So this is what the
That's the
form itself
microphone.
says. In open court and on the record, I hereby waive my right to an attorney in this case. I have been fully advised of my right to be represented by an attorney, including my right, if applicable, to have an attorney appointed by the court at no cost if I qualify. I agree to proceed without an attorney at this time. This says, I have been advised of the charges against me and the maximum possible sentence they carry. I have also been advised if there are any mandatory minimum penalties which might apply. And then it says, in witness whereof, I have hereunto subscribed my signature this 25th day of November, 2025. So do you understand?
Yes.
Now let's talk about the penalties because I said I advised you of them, but I haven't yet. So in this particular case, you're charged with speeding. That's a minor misdemeanor with a maximum $150 fine. You're charged with failure to dim your high beams. Also a minor misdemeanor, punishable to a $150 fine. And you're charged with operating a vehicle while impaired.
Send him to jail. Do not let him out. If he doesn't know how to turn his high beams off, he can go to jail. Yes, he can. We're not having this. No.
And it would be a second offense within a 10-year period. Therefore, the penalties are up to 180 days in jail,
17 years in jail.
up to a 7-year suspension of your license,
Oh, that's good. I like that one.
and a fine of up to $1,625.
$18,000 to me.
Do you understand?
Yes.
Now, at a minimum, on the OVI charge, the court must impose a fine of at least $715. Oh, nope, he's grandfathered in. At least $565. At least a 1-year suspension of your license,
Wait,
and at least 10 consecutive days in Licking County Jail.
what? That is. He got 180 days for speeding. He got a 7-year suspension for speeding. And then for OVI, he got 7 days and a 1-year suspension? Isn't that backwards? Shouldn't OVI be substantially more than speeding with your high beams on? I must have missed something. I must have missed when they said high beams on, I got raged. So I don't know what he said after that. Hopefully there was like a murder or something after that that I missed to make that so high, although I agree. And I'm very happy that you get suspended for 7 years for having your high beams on. Gonna kill someone.
So, with that being said, is it your intention to waive your right to have an attorney in the one case that we've been discussing, with the understanding that Mr. Brigden at that point would be permitted to speak on your behalf? So is that what you want to do? Okay. The bailiff's going to provide you with that form that I just read to you. If that's your decision, go ahead and sign by the X.
That's awesome, Anna. You're healing.
Okay, Mr. Kotka, is that your signature?
Mr. Kaka.
Yes.
And is it your intention on that case only to waive your right to an attorney?
Yes.
All right, very well. So, at this point, in the 1794 case, we have the OVI, the speeding, and the failure to dim. We've already gone over the maximum and mandatory minimum penalties for those offenses. Did you have any questions?
Blind them with bright lights for 36 hours.
No.
Okay, so let's talk about the 6415 case.
15
You're charged with operating a vehicle while under the influence.
Another one?
It's charged as a second offense within a 10-year period. And so the maximum and mandatory minimum penalties are the same for the other OVI offenses.
What?
Explain to you.
What?
You understand that?
No, I don't understand that.
You're also charged in this case with driving while under an OVI suspension. That carries up to 180 days in jail and up to a 1-year license suspension. You could be fined up to $1,000. This offense carries mandatory minimum penalties as well.
This is crazy.
It's at least a $250 fine, at least a 1-day license suspension, and at least 3 days in the county jail. Now, that would be required to
3
be
days
served
for a
consecutively
DUI.
to the mandatory minimum sentence on the OVI. So, in essence, if you plead guilty and I accept your pleas, I'm required to sentence you to serve at least 13 days in jail in this particular case.
Okay, hold on. Maybe I'm wrong. Maybe when I hear OVI, I think operating while intoxicated, but maybe it means operating without insurance. Maybe it's not a DUI. Maybe I'm wrong. Right? Because, what? His second DUI gets like one more day in jail? That doesn't make sense. But if it's operating without insurance, that all makes a lot more sense, right? It's Ohio. I should Google it, but I'm not going to.
You understand?
बुझ्नुभयो? Yes.
And the agreement that was reached between you and your former attorney,
तपाईँको पहिलाको वकिलसँग
between the prosecution, I should say, and your former attorney, would be that the state would not object to the
Okay, that makes the
minimum
best
sentences,
sense.
गर्दैन कम्ती सजाय लागेको
but that they be served consecutively.
Oh,
that they be
you're
served
right.
consecutively
OV, not
to this other
OW.
appeal.
अर्को मुद्दा
He said OVI.
So your total mandatory time would be 23 days. Do you understand?
अनिवार्य 23 दिन जेलमा बस्नुपर्छ
Understand?
Operating vehicle
Now, Mr.
intoxicated.
Adhikari, has anybody threatened you in any way or promised you anything in order to get you to do what you're doing here today?
तपाईँलाई कसैले केही दिन्छु होइन यो चाहिँ गर्दै भनेर लगाएको कि आफ्नो स्वेच्छाले तपाईँलाई चाहिँ यो मुद्दा
Operating while visually impaired?
No, willingly.
That's what I thought, Monica.
Are you under the
Operating
influence of
vehicle
anything?
आज
intoxicated.
कुनै मदिरा खाएर चाहिँ अशक्त हुनुहुन्छ भएको छ? No.
Instead of
Are you
walking.
satisfied with Mr. Brigden's advice and representation?
भने तपाईँको वकिलले दिएको सरसल्लाह उहाँले कति
Fine, I'll Google it. Fine.
And are you a citizen of the United
Fine.
States of America?
अमेरिकाको नागरिक हो तपाईँ? No.
I am required to read you the following language.
तपाईँलाई चाहिँ यहाँ के छ म अनिवार्य पढेको सुनाउँछु
If you're not a citizen of the United States,
अमेरिकाको नागरिक होइन भने
you're hereby advised
हामी तपाईँ
the conviction of the offenses to which you're pleading guilty
जुन आज अपराध स्वीकार गर्दै हुनुहुन्छ आज
may have the consequences of deportation,
सक्छ भने देशबाट त्यही देशमा
exclusion from admission to the United States,
रोक गर्न सक्छन्
or denial of naturalization pursuant to the laws of the United States.
कानुनमा त्यस्तो लेखिएको छ
Understand?
त्यो बुझ्नुभयो Yes.
Now, if you wish to
Same as
consult with an
DUI,
immigration
operating
attorney or
vehicle
specialist
अप्रवासी कानुनसँग सरसल्लाह गर्न चाहनुहुन्छ
in order to discuss the possible impact of these convictions on your residency status,
यस्तो हुन सक्छ भनेर
the court would grant you a continuance to do so.
तपाईँलाई आज नभएर अर्को दिन पनि गर्न सक्छु
However, you're not required to continue the case
गर्नुपर्छ भन्ने छैन
or to consult with anybody else if you don't want to,
यदि कोही छैन भने
and you can proceed with your guilty pleas and end your case today. Do you understand that?
त्यो बुझ्नुभयो Yes.
And would you like that opportunity, or are you okay going forward today?
वकिलसँग सरसल्लाह गर्नुहुन्छ कि आजै सिधा हुनुहुन्छ फेरि ट्राई गर्नुहुन्छ Yeah, I have been trying for the immigration attorney, but I have not yet found. So still, I want to take the opportunity and look for the.
You wanted the opportunity to talk to somebody about this
Yes, somebody
that specializes in
Yes.
immigration matters? Okay, very well.
Your Honor, that was the basis that we continued this on October 18th.
Oh,
Give some
अक्टोबर
light.
18 तारिक पनि यही भनेर चाहिँ छोडेको
so your attorneys explained that I gave you this option before,
तपाईँलाई पहिल्यै विकल्प दिइसकेको थिएँ
and you've had ample opportunity to do so.
प्रशस्त समय दिएको थिएँ तपाईँलाई
So I guess the offer to continue the matter would be rescinded by the court.
भनौँ अब यो चाहिँ फेरि निरन्तर दिन सक्छ
That was October 14th to be
Okay.
exact.
अक्टोबर 14 तारिकै दिएको थिएँ
However, I cannot force you to change your plea if you don't want to.
यदि तपाईँ म चाहिँ होइन अपराध स्वीकार गर्छु भन्नुहुन्छ नि गर्न दिन्छु म
But if you're okay with resolving your case and ending it today, then we can end it today. It's up to
यदि
you.
तपाईँ चाहनुहुन्छ आजै मुद्दा छिनु खानु
He could have been high on life, you know.
So do you want to do today?
के गरेर आजै गरेर सिधाउन चाहनुहुन्छ Yes.
Okay, very well. Then I'll accept the pleas as having been knowingly, intelligently, and voluntarily made.
विवेकले आफ्नो बुद्धि लगाएर चाहिँ मैले स्वीकार गरेँ
The state has filed a motion to dismiss the refusal charge in the 1794 case.
गरेको चाहिँ राज्यतर्फबाट मिना भयो मुद्दा
That motion will be granted.
चाहिँ उहाँलाई स्वीकार
Mr. Brigden, would you care to make a statement on behalf of your client?
आफ्नो कुराको बारेमा केही भन्न चाहनुहुन्छ ब्रिटेनज्यू
Your Honor, we would just ask the court to follow those pretrial negotiations.
It's not fair if you didn't know.
स्वीकार गर्नुहोस्
And my client would ask for a report date of December 29th.
अनि अर्को डिसेम्बर 29 तारिक चाहिँ म आउँछु
We would ask the court to consider that.
त्यसमा स्वीकार गरिदिनुहोस्
Thank you.
धन्यवाद
Mr. Kodka, you have a right to speak before I make any decisions about your sentence.
अधिकार छ बोक्ने
Mr. Kaka.
There's
There's
नबोल्नु पनि
no requirement that you do so,
अनिवार्य
however.
बोल्नै पर्छ भन्ने छ
Is there anything you'd like to say, sir?
के भन्न चाहनुहुन्छ
मैले आउने कुरा like 29 Yeah, 29 मा start सबै
Starting for 29.
सबै कुरा financial कुरा
I just arrange my financial status so that 29 is fine.
Okay.
Anything?
Has anybody seen Kit Kat
Okay.
anywhere?
Mr. King?
Can you catch up?
Just to point out, Your Honor, obviously alcohol is a problem.
So your समस्या हो
Defendant had been previously convicted on May 24th, 2021,
2021 में
and he was charged again in March of this year as well as
मार्चमा पनि गरेको हो
July of this year.
जुलाईमा पनि हो
Obviously, he needs to seek some sort of counseling or
उहाँलाई केही
assessment.
किसिमको सम्झा बुझा गर्ने उपचार चाहिन्छ
Other than that, I am okay with the mandatory minimums.
मलाई अनिवार्य
Have been
जति
discussed.
सजाय दिएको छ म त्यसमा स्वीकार गर्छु
Thank you.
धन्यवाद
I had children, so I don't have to drink and drive. Judge, I'll show you my driving's fine. Let's go race. There was a mistake at my job the other day. One of the servers poured a glass of wine. It was the wrong wine. So it sat there, and it sat there, and it sat there. And the other server didn't get rid of it. It just sat in the back of the house. And then the end of my shift, I'm like, no. I gave everybody in this place a chance. It sat there forever. It's mine now. So I put it in a to-go cup. And I put it in the back of my car, in the back door, on the other side. But I'm driving home and I'm like, oh my God, I'm going to get pulled over. I'm going to get pulled over. I have an open container in the car. Because that's the point where I would just definitely get pulled over when I do something stupid like that. But it was worth it because it was delicious. Back seat for drinking? Huh. I always did other things back there. Like taxes. I have sparkling Moscato ready for Thanksgiving. Yep, that's my contribution was alcohol and pie. Thank you, Kelly. No, but I wanted to. And it wouldn't have been illegal because one glass of wine is not illegal. But I wanted to. But instead, I brought it home. Yeah, but I'm always .05. That's not fair. I can't drive. I'm gonna buy one of those breathalyzers. Carry it around with me.
The plea forms for 612 here.
2020. Lean. I will, Kelly. Zima. Tequila lollipops.
Yeah, he has a green card, so
I'm craving a steak. A big steak. And I'm gonna have a shit ton of turkey tomorrow, so I don't know why. $51. Go ask her for more. Tell her you how to use eggs. And gas to get the eggs. And electricity went up. And to heat the oven, that went up. $1,000. I always overcharge my friends. Judge, what are you doing? I forgot we were in court. Because we're talking about so much else. He is...
All right, very well. It's going to be a sense of the court as follows. In case number 25 TRC 1794, on the speeding charge, the court will impose a $34 fine. On the failure to dim it, will be a $25 fine. On the OVI, it will be 180 days in the county jail. 170 of those days will be suspended. I'll provide that if the defendant has any credit as a result of being incarcerated on this case at any time, he shall receive credit for that time towards the 10 days that he has to serve. He'll be on probation for 1 year. He'll be required to abstain or abstain from alcohol, not consume any alcohol, no drugs, no abuse of prescription medication. If you're asked to submit to a drug or alcohol test by your probation officer or any law enforcement officer, you're required to submit. I'm going to order that you undergo both a drug and alcohol as well as a mental health assessment, because if there are issues on both fronts, we need to deal with those at the same time. You're to maintain suitable employment and follow any other rules the probation department sets. You're going to save a little bit of money on the fine on this because the effective date of the increase of the mandatory minimum fine was after you were cited. So your fine on this charge is $565. It'd be a 1-year license suspension from the date of your citation, and the defendant has served the mandatory hard time. As noted, the court is granting the state's motion to dismiss the A2 charge. In 25 TRC 6415, on the charge of OVI, court will impose a 180-day jail term suspend 170 days of the jail term, and grant the defendant credit for any time he may have served while being held in the jail. He'll be on probation for a period of 1 year with identical terms and conditions. The fine on this charge, the mandatory minimum is higher because the effective date was April 9th. Our charges filed after that were subject to the increased mandatory penalties. So the fine on this charge is $715. Court will suspend the defendant's license for 1 year, effective from the date of the ticket. That's July the 8th. On the driving under suspension charge, the court will impose a 3-day jail term, a $250 fine, 6-month license suspension effective
No,
today.
Josh. No.
And the court will provide that all jail terms imposed between the two cases will be served consecutively. And therefore, the defendant has a total of 23 days to serve, less any credit he may be entitled to for being held in lieu of bond. What was it that I was going to put in that I didn't think that I did? I saw something, I was like, oh yeah, oh, I think a report date. Nope, didn't put a report date down. Now, I'm going to order that the defendant report to this courtroom on December the 29th, which is a Monday, at 11 a.m. He'll be given written instructions on what he needs to do so there can't be any misunderstandings.
Who else thinks Mel and Tona are the same person? You guys talk about your husbands and they're identical.
It is incredibly important that you show up when you are supposed to for this, because if you don't, then a warrant will be issued for your arrest. Instead of doing 10 days on each of the OVI charges, you could end up serving the entire balance for a total of 1 year in jail. And to add insult to injury, the court could find you in contempt for failing to report and add 30 days onto each case, and thereby turning your 23 days of mandatory jail time into 1 year and 2 months of jail. So you need to make sure you have all your arrangements in place well before the day you report so that you can be here. And if I tell you to be here at 11, if I were you, I'd be here at 10:30. Now, Mr. Kodka, the court considers this behavior to be terribly concerning. We don't handle murder cases or rapes or robberies, but people are killed on a daily basis in our country by impaired drivers. I pray that you'll take your treatment and programming seriously, because it's nothing short of a miracle that nobody's been hurt in any of your cases before. And if you continue to drive while you're impaired, the odds are good that we will have a tragedy. So, it's time to make sure that we really deal with why you're sitting here today.
Leaving your
Do
headlights
you have any
on.
questions, sir? Anything further, Mr. Brigden? Anything else, Mr. King? Very well. You're going to go with the bailiff, and he's going to go ahead and the interpreter will go with you and continue to assist. Now we're ready for Donnie Dowdy. Donnie Dowdy.
We're going to stay for Donnie Dowdy and then we'll end it. Just because I love the name Donnie Dowdy.
This is 25 CRB 788, State v. Donnie Dowdy. That's you, sir?
Yes, sir.
Record to reflect the defendants present in the courtroom today with counsel, Mr. Brigden. We have Mr. King here on behalf of the state of Ohio, and this matter comes on for further hearing, having been scheduled for a change of plea. The defendant is charged with spotlighting deer while hunting, a misdemeanor of the 3rd degree, and in fact, all 4 charges the defendant's apparently going to change his plea are 3rd degree misdemeanors. There's 3 counts of state ownership title of wild animal. Third-degree misdemeanors are punished by up to 60 days in the county jail, up to a $500 fine, and the defendant would be subject to a suspension of his hunting privileges in the state of Ohio. And that could be a period up to 3 years. And I can't remember, I don't believe, oh yeah, and there is
Spotting deer?
the possibility of an order of restitution as well. Do you
Spotting
understand?
deer is illegal?
Okay. And is it true that you're going to be changing your pleas from not guilty to guilty?
Yes, sir.
And are you aware that you're not
All right,
required?
I'm stupid. I am stupid. I don't know. Isn't spotting deer just when you drive in your car with this big light? Is that illegal? Judge, why are you making me work so freaking hard today? I'm Googling it. I'm Googling it to figure out what the hell is going on right now. Okay, spotting deer is to shine a big light to make deers freeze. I guess you're not allowed to spot. It's against the law to hunt deer with a light because they freeze. That's
To do that.
Yes, sir.
Do you realize that as you sit before me, I have to presume that you're not guilty of the offense? And I don't think I said it, but the defendant's here with his counsel, Mr. Brigden, and Mr. King is here on behalf of the state. Do you understand that you're presumed to be not guilty? The state has the burden of proof here.
Yes, sir.
And did you know that that burden is proof beyond a reasonable doubt?
Yes, sir.
Are you aware that you have a right to a trial with a judge or a jury?
Yes, sir.
And did you know that at the trial you could, number one, cross-examine your accusers, number two, subpoena your own witnesses to compel their attendance, and finally, number three, you would have the right not to testify, and it wouldn't be held against you if you didn't. Understand?
Yes, sir.
If you plead guilty, however, you admit to committing these offenses. It means the state no longer has to prove anything in order for me to find you guilty. It means you're surrendering your presumption of innocence. And most importantly, it means you're going to be waiving the rights we've discussed, including your right to a trial. Did you realize that?
Yes, sir.
And if I accept your pleas and enter convictions, I'm going to impose a sentence upon you today. Did you have any questions about the possible?
JK, is that illegal?
Have you been threatened in any way or promised
Are you not
anything
allowed to
you
do
what
that?
you're doing here today?
It'd be stupid
Are
to
you
do
under the
it,
influence
but
of anything right now?
No, sir.
Are you satisfied with Mr. Brigden's advice and representation?
Very much.
And are you a citizen of the United States of America?
Yes, sir.
All right, then the court finds that the pleas and waivers have been knowingly, intelligently, and voluntarily made. The court will accept the same and enter convictions on all four charges. Mr. Brigden.
Thank you, Your Honor. With regard to this, we had discussed the $500 fine, the loss of the license for 3 years, and the surrendering of the weapon. Mr. Downey has brought the weapon and has been surrendered. I will note that he's taken this matter seriously. In the beginning of this, which this case, originated a little over a year ago, Mr. Dowdy's recitation of the facts are that the animal was actually killed in West Virginia and brought up here. He self-reported to West Virginia, lost his license for a year there, and paid numerous fines.
shooting fish in a barrel, JK, is in fact illegal. You're not allowed to do it.
There as a result of it. It is, I know the state contends that it was shot here. It is a tribal fact that Mr. Dowdy wants to conclude this matter, so, he is pleading guilty to those elements of the state title ownership. But ultimately, there wasn't a tag on it. It was here in Ohio. I would argue, however, Your Honor, though, that the three state title or ownership would merge because it's the same animals. So I believe one was out of season, the other was no tag, and actually just scheduled the third one.
It looks like count 2 is hunting from a motor vehicle. Count 3 is hunting with a rifle during presumably crossbow season.
Can't hunt with a rifle,
Oh.
not that 2.7.
Gotcha. And then finally, the last one is failure to check the game. So they're actually all different aspects of requirements for hunting. But I mean, go ahead and make your argument.
Yeah, I'm arguing those are all still the same.
But you can fish with a spotlight. I know that's legal. I know it is. I know. Because all the night fishermen have spotlights. On their boats, on the docks. So you can fish with a spotlight. And you can shoot a deer. But you can't reverse that. You can't hit a deer with a spotlight and shoot at a fish with your gun.
Animus, I mean, I know you can put it into the test and whether or not one can withstand on its own, you know. I'm arguing just for the sake of preservation of the record that there would be a merger at least from the out of season and the hunting with a gun, or the gun one. It's
Sure.
kind of the same thing. At any rate, he took this matter seriously. He hired private counsel. He's come up here. And again, as I said, I think self-reporting in West Virginia shows that he demonstrated remorse for his actions. So we'd ask the court to follow that through trial negotiation.
All right, thank you. Mr. Dowdy, you have a right to address the court before I make any decisions regarding your sentence, although you're not required to. Is there anything you'd like to say, sir?
No, sir.
And Mr. King, anything further from the state here?
Yes, Your Honor. Not to belabor it, but we don't believe that deer was shot in West Virginia at all. Another individual who's been charged in multiple counties, Todd Brown, would testify he was absolutely with the defendant. The deer was in fact shot from a gun, utilizing a spotlight after hours with a high-powered rifle, and that rifle was a .270 caliber, which is illegal to use in the state of Ohio. It's not a straight-walled cartridge, and that he left this state without checking that animal. The animal, I think, was rotten by the time it got back. Normally, I would ask for a forfeiture of the antlers. It's illegal for him to possess them. On the other hand, it's my understanding that West Virginia wildlife officers have seized it. Nevertheless, these are serious charges. You don't do that. We are sticking with our request for a 3-year loss of hunting license. Are asking for restitution for $500. We don't have the buck, so the Ohio Administrative Code sets for an antlered deer the minimum restitution value, which is $500. And finally, my notes back on September pretrial indicate possibly a weekend in jail or forfeit the rifle. I will verify that the rifle has been forfeited, is currently in possession of a wildlife officer. I meant to get to, but today has not gone well. I will get the court an entry regarding the forfeiture of that .270 Savage rifle, as well as the restitution for the $500 for the antlered deer. Thank you.
Which count is the state proposing to order this the license, the privileges suspension, as well as the restitution and
I don't
the
think
forfeiture?
it really matters. Do you have a
It would
preference?
be one of the taking charges, so it would be either the rifle or the jacklighting.
Okay, they're probably the first or the second, either the spotlight or jacklighting, or shooting the deer with the high-powered rifle.
Okay, thank you.
I suppose I should also, for what it's worth, put in my 2 cents. Hunting violations are strict liability offenses. That being said, these do not merge. Separate acts are required for the commission of each and every one of them.
All right, the record will so reflect. Is the restitution to be paid to ODNR itself or to the state of Ohio?
ODNR itself, otherwise state of Ohio will keep it.
Well, we do need one more Loge box in the new Cleveland Brown Stadium. Okay, it's going to be the sense of the court as follows, and incidentally, I concur with the Assistant Law Director's recitation of what was discussed at the pretrial conference back on September the 9th. On count one, spotlighting deer, it's going to be a $200 fine. Cost will be assessed. The defendant's hunting privileges in Ohio will be suspended for a period of 3 years. On count two, it's going to be a $200 fine. The court will order that the rifle that was used to commit that offense be forfeited to the state, and I put ODNR in parentheses. And then finally, on that count, the court will order the order of restitution of $500 to the ODNR. On the two remaining charges, will be a $200 fine on each. You'll actually get time to pay if you need it, Mr. Dowdy. If you can pay it off sooner, then that's entirely up to you. But, I will say this. But the first line of my notes from the pretrial conference says, "State wants head on a platter." ODNR took this one very, very seriously. They were very, very upset about the behaviors here. You're an experienced hunter. You know what you need to do and what you can't do, and unfortunately, you're going to suffer some consequences here. But after 3 years, you're going to be able to come back and hunt if you like. Just make sure you follow the rules. Do you have any questions?
No, sir.
Anything further, Mr. Brigden?
No, Your Honor.
Anything else, Mr. King?
No, sir.
All right, very well. And I will entertain those proposed motions from the state regarding restitution and forfeiture. Okay, and finally,
All right, guys, we made it to the end. What a day. All right. What is today? Tomorrow's Thanksgiving. I will be streaming tomorrow morning with my Thanksgiving table behind me. I don't know what I'm going to stream. I'm thinking of doing that Church's Chicken one I did a while ago, and I just redid it on my other channel, because it's chicken, and tomorrow's Thanksgiving. So I think I might do that. So if you just watched it on my other channel recently, then you can sleep in, because I think I'm doing Church's Chicken and something else. That's not a 2-hour clip. But if I see you all tomorrow, that's great. If not, happy Thanksgiving. Spend time with your family, only if they're not toxic. If they're toxic, don't. Spend time with family that support you tomorrow. Okay? And eat too much. And if you're safe, drink too much. And then Friday, I expect you all to join my live stream hungover. Yep. That's all you gotta do. Alright, guys. Thanks for coming out. I'm gonna set up OJ now. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.